So good afternoon, everyone, and welcome to the panel Due Diligence in Cyberspace. This event is organized by the Washington Foreign Law Society and Stimson and supported by the DC Bar and the Lewis Alumni Association DC chapter. I'm Giuliana Canet, the former president of the Washington Foreign Law Society and current chapter leader of the Lewis Alumni of Washington DC. As you might know, the Washington Foreign Law Society was founded in 1952 to promote the knowledge and understanding of international legal matters, comparative legal issue, and foreign law. If you're not yet a member, we invite you to become one today. Given the number of participants, you will be muted during the webinar. The webinar will be recorded. You will be able to communicate with us through the Q&A section. I would like to thank you already for the questions submitted at the registration for our distinguished panelists. You can still have a chance to send the question in the Q&A section, and we'll get to your question toward the end of the seminar. Don't forget to follow us on Twitter and LinkedIn. I will put the link on the chat box shortly. And I would like now to introduce our moderator for today, Dr. Christopher Ford, who is a visiting fellow at Standard University Hoover Institution and a visiting professor at the Missouri State University Graduate Department of Defense and Strategic Studies. He has a very long bio, and you can read his full bio in the invitation to this event. Dr. Ford will introduce our panelists. Welcome to all. And Dr. Ford, the floor is yours.
Thank you so much, Juliana. Hopefully everyone can hear me okay on this device. Wonderful. Well, good day, everybody, or I guess good evening to those of you in different time zones, or perhaps good morning, depending upon the location from which you are joining us. But whatever the salutation, thank you for attending this webinar. As you've heard, sponsored by the Washington Foreign Law Society and the Stimson Center. As you heard also, my name is Chris Ford, and it is a distinct pleasure to be able to moderate this discussion with some fantastic experts who are joining us today. Now, the topic that we're discussing is an important one, and it is not by accident that we are talking about it today. Sparked by things such as the epidemic of ransomware attacks that seem to have blossomed a couple of years ago, there is growing concern about how our society will be able to handle the increasingly common use of cyber tools, not just for crime, but for all manner of malicious activity, all the way up to attempts, perhaps, to inflict crippling harm upon civilian critical infrastructure. Now, if you're interested enough in this topic to be on the webinar, you probably don't need me to recount the litany of problems, but there are a great many that we have come to face in this regard. Well beyond just the, sort of the data exfiltration of cyber espionage, we've seen malicious cyber activity from a whole range of actors, including terrorists and state actors as well, and those acting directly or perhaps indirectly on behalf of states. U.S. officials have been warning about dangerous vulnerabilities for years, going all the way back at least to the mid-1990s and accelerating with things like Leon Panetta's famous warning in 2012 about the emerging possibility of a cyber Pearl Harbor, the study by the Defense Science Board on this in 2017, and all sorts of official threat assessments since then. So clearly the complicated information infrastructure of modern society remains dangerously susceptible to such activity. We've seen lots of instances that drive that point home. Right? We've seen ransomware shut down operations at the Colonial Pipeline here in the United States. We've seen North Korea use cyber theft to support its WMD programs. We've seen Russia's NotPetya attack on Ukraine ricochet around the internet, causing all sorts of harm far beyond its intended targets, crippling companies and consumers and all that sort of thing. All sorts of actors have been working to take advantage of the relative degree of anonymity that cyber tools can offer to hide their destructive cyber mischief behind the deniability, which is, sometimes plausible and sometimes not so plausible, but in order to protect themselves from accountability. And you can't forget, after all, Vladimir Putin sort of smirking just before unleashing NotPetya in his comments publicly that he considered Russian hackers to be like artists who, if they have patriotic leanings, may try to add their contribution to those who speak badly about Russia. So clearly we have a problem, and the Washington Foreign Law Society and Stimson are closely engaged on all these sorts of issues. Now, those of you who joined us last time at our last cyber webinar will remember that we focused there upon the challenge of attribution in cyberspace and how it might be possible to do more to improve accountability for malicious cyber activity by improving its attribution to its genuine authors. Now, I thought that was a terrific discussion with some fantastic experts, and this webinar is going to pick up where that one left off. Now, this one proceeds. Today, we are working, in a sense, on the basis of the insight that accountability can take various forms. Last time, we looked at direct accountability, if you will, in the form of who actually was the point of origin for an attack. And today, we're here to explore the possibility, at least, of another form of accountability, which you might think of as more an indirect form of accountability, or what you might think of as perhaps a kind of complicity even. So what we're looking at are issues of due diligence and state responsibility in cyberspace. And this relates to whether and the degree to which states have responsibilities to ensure that their territories, their cyberspace maybe, if you will, isn't used for malicious activity against others. And we'll be talking about what states must do to live up to any such responsibilities they have. Now, to me, and this is not me speaking as Chris the lawyer, but as Chris just the person, this seems pretty reasonable, even if there remains debate and disagreement about the details and doctrinal status. There is a commonsensical idea, I think, that in some contexts, even if you can't reach specific actor attribution, the originator is not the only party, or not always the only party, at fault. Others may also bear some blame, and perhaps themselves be held accountable. It's pretty commonsensical that even if you can't tell who exactly is the originator of some kind of harm to you, it would matter whether they are operating, if you will, out of my house. Or it would matter whether or not I know that they're doing this out of my house and whether I have the opportunity to stop it. And so at some point, this insight suggests you perhaps may indeed have a real grievance against me for any de facto permission that I give perhaps to such bad guys. Now, I recognize that in matters of law, as elsewhere, something that may seem straightforward and feel right in principle can be rather more complicated in its doctrinal foundation and its practical application. And as it turns out, the concept of due diligence in cyberspace is not universally accepted, I should say. And there actually is some very interesting debate on these points. But the answers are going to matter. I mean, some published analyses have ranked countries on the basis of the degree to which they are the point of origin for malicious cyber activity. And you will not be shocked to learn that China is at the top of that list. But it's interesting also that considerable numbers of attacks are said to originate in the United States, in Brazil, in India, in Germany, to name a few. So those are some pretty major players. So it's not hard to see how the answer to this question of what responsibilities jurisdictions of origin might be said to have is a really important one, and why it's complicated and why this is challenging. So that's why we need real experts to help walk us through this, and we are fortunate today because we have some. We have a couple of fantastic experts here on hand, and I am delighted to introduce them. Now, Maria Salazar Albornoz is a professor of international law, international humanitarian law, and international criminal law, Iberoamericano in Mexico City. She recently concluded a 4-year mandate as a member of the Inter-American Juridical Committee of the OAS, where she served as rapporteur on international law applicable to cyberspace. Among other responsibilities, she is currently a member of the ICRC's Global Advisory Board on the protection of civilians from digital threats during conflicts, as well as on the editorial board of the International Review of the Red Cross. She's got a law degree from Universidad Iberoamericano and a master's degree in international law from the Graduate Institute of International and Development Studies in Geneva. Joining her to help us understand these weighty legal and policy issues is Dr. András Casteller, lead cybersecurity researcher of the Security and Technology Program at the Nations Institute for Disarmament Research in Geneva. Prior to joining UNIDIR, András held various research positions in different international organizations and research institutions all around the world. He holds a PhD in international law and an MA in diplomacy and has written extensively on these topics, both for UNIDIR and elsewhere. So these are clearly fantastic experts to walk us through this, and I'm eager to hear from them, and you are probably eager for me to stop talking. So let's start off. Turn to our panelists. András, let's start with you, or if you'll permit me to call you Andy, as I've heard some people do. Thank you. In case members of the audience aren't really familiar with the backstory here, I was hoping you could perhaps give us a brief account of what is meant by due diligence in the cyber context, and what would this concept if it were the rule, actually require states to do.
Mm-hmm. Thank you. Thanks, Juliana and Chris. I'm very grateful for this opportunity to be here and speak on this topic. I think it's indeed quite a hot topic, and it's gaining quite a lot of traction in multilateral discussions, especially when it comes to cyber. Now, Chris, I think you tried summarizing already, and you've said a lot about, but I'd like perhaps to refer.
Please correct egregious errors.
No, not correct, not at all. Far from it, but points in the direction of the past jurisprudence and ICJ judgments on this particular topic, because I think they're quite pertinent in this regard. And one in particular is the one from the late 40s. I'm pretty sure everyone's familiar with it. It's called the Corfu Channel case. It was a dispute between UK and Albania involving some mines and ships. But in that particular judgment, I think the court recognized very well the due diligence principle by saying that there's every state's obligation not to knowingly allow its territory to be used for acts contrary to the rights of other states. While this may seem a bit of a mouthful, in essence, this means that states must not only comply with international obligations on one hand, or in other words, refrain from violating their obligations and respect legal rights of other states, but they must also exhibit a degree of diligence in protecting the rights of other states from the malicious or unlawful acts coming from their particular territory. So in essence, due diligence principle is highly connected to the principle of territorial sovereignty. Now, the principle is not only recognized in that judgment that actually started way before, but it has seen adoption after the late 40s in various legal regimes. I think most notably international environmental law and diplomatic law. And I guess this would be an argument for labeling due diligence a principle and not necessarily a standalone rule of international law, just very limited in its scope. Now, this is sort of the traditional doctrine, and I think in cyberspace, if we are talking about cyberspace, as you mentioned, the normative or doctrinal status of due diligence as a principle is largely unsettled. I think states have recognized due diligence in the norm C of the 2015 and 2021 GG reports, which have been subsequently recognized by the General Assembly. But as we know, so the norm C has a very specific language that is highly similar to the judgment that I referred to before, so the ICJ judgment on Corfu Channel case. But nonetheless, this is a norm, and norms, at least in this particular context of multilateral discussions of rules of state behavior in cyberspace, are voluntary in nature. So they're in essence political commitments. I mean, that's why norms say states should, in this particular case, should not knowingly allow their territories to be used and carry no legal repercussions. And now if we put these discussions in a context, like you mentioned, of state responsibility, I think that is quite important. So there's no secondary obligations as suggested by customary international law of state responsibility, and by virtue of that, that may have an impact on compliance. And I think this is not a universally accepted premise. A lot of states actually, in their individual opinions, so ones that have not been negotiated through a lengthy international multilateral process, some states actually argue that due diligence is a principle that imposes certain obligations also in cyberspace. I counted more than 10 when I was reading through these statements, but I mean, it doesn't seem much, but it's actually quite a lot given how many states have publicly pronounced their position on international cyberspace. So I think a number of states do argue that due diligence has obligations. I'll go into the content a bit later. And this debate hasn't really stalled. In just last week in New York, the fourth session of the OEWG, the states, well, there was a couple of them that have said that the multilateral discussions should, or negotiations should, continue debating due diligence, and hopefully by the end of 2025, or maybe even in the annual progress reports, we'll see some additional clarity as to, or in relation to, the normative status of due diligence, perhaps also on the scope of due diligence. I guess time will tell. I hope that's short enough.
Well, that's very helpful. And Mariana, let me turn to you. In your rapporteur's role, you've surely been following these debates extraordinarily closely and perhaps been involved very directly in them. How would you describe, I mean, first of all, what would you add these account, but also how would you describe the current sort of state of play of these debates? You know, who are the major players, and are there, you know, sort of conceptual factions that are sort of feuding over this? How would you just, you know, give us a feel for the how this terrain is being contested right now?
Thank you, Chris, and thank you to the Stimson Center. It's an honor to be invited, to have been invited to participate in this event. So indeed, Andy gave an excellent review of the concept of due diligence and the state of the debates. I would add that due diligence, as he aptly mentioned, is not new. It comes from even arbitral decisions from before the Corfu Channel case. The Corfu Channel case, which is the main reference for this principle, is from 1949. We have some arbitral awards before that. And then also, I want to add that we can also find some other rules that are similar to a due diligence or a precaution obligation, besides from environmental law. Also in international human rights law, there is a duty to act diligently to protect human rights within the state's jurisdiction. And this is a delicate issue that I can come back to afterwards, but also international humanitarian law. International humanitarian law, which applies in armed conflicts, has an obligation to not only respect this body of law, but also to ensure respect. And it also has an obligation to exercise precaution in order to protect civilians from indiscriminate attacks during armed conflict. And all of this involves certain duty to exercise diligence, to exercise precautionary measures, right? We can also see a duty to prevent genocide in the Genocide Convention. And we can also see some obligations regarding the law of the sea that also have some precautionary issues. Also the duty to prevent crime in the Palermo Convention and some other conventions. So this is something that we can, and I'm saying this because I fully agree with Andy in the sense that we can see a general principle of international law. And this is why there has been a kind of a false debate around the issue of whether cyberspace is a different domain. And then if we should say that due diligence does not apply to cyberspace because there are not specific rules for it. At the time being, there is no reason, in my opinion, to say that this general principle of international law does not apply to cyberspace. Of course, if there are new specific norms, that is something to be seen, and that would be a special or lex specialis, a special body of law, right? But we do have an existing and applicable body of law at the moment. This is my point here. And as for the state of the play and who are the main actors, well, just to give a review, Andy was speaking about the open-ended working group. So many of the people who are here already know about the fora where this has been debated. Some others might be new to the topic. So the topic of the use of information and communication technologies has been in the UN agenda since 1998. However, it's been a long process. Many different governmental expert groups, GGEs as we call them, open-ended working groups. Right now we are in the process, after I won't go into the details, but right now we are, as Andy mentioned, in a process that's the open-ended working group. This group is sessioning between 2021 and 2025. In all these years, there has been very little advancement regarding the extent to which international law, including due diligence, applies in cyberspace. States have been very cautious, and in the main actors, as you have asked me, I believe I would say are the Europeans, Western Europe principally, and others, the Western European and others group, the WEOG as we call it. So from the other regions, and I will speak for the Americas, the region of the Americas, as my mandate was in the Organization of American States, basically only 3 countries have issued a very complete or comprehensive, maybe not so much regarding due diligence, but more comprehensive national positions that have been published. And these are Brazil, Canada, and the United States on the applicability of international law to cyberspace. There are some other states in the Americas that have, due to some efforts that we have done in my previous mandate in the Inter-American Juridical Committee, where my predecessor, Duncan Hollis, was also rapporteur for this topic, and he circulated a questionnaire. We have identified some specific answers to some of the issues of international law applicable to cyberspace. And we could say that there are in total nine other positions besides from the three that I mentioned. So as you can see, to give you just a general overview, states have still to pronounce themselves, to issue their national positions. There are around 26, I believe, national positions throughout the world that have been published. So we are still waiting for more. And this is where we're standing. It's been a very long process, and states are very reticent. So much of the advancements have come from academia and from other types of institutions. The Oxford process, for example, is an excellent, they issued an excellent report on cyberspace and due diligence in cyberspace in 2021. Andras and Unidir also issued a very important report on this. The talent manuals, which were an academic exercise, are also a good source. And the International Committee of the Red Cross, limited, of course, to the issue of international humanitarian law, but has also done position papers, regional consultations, which are helpful in this topic. And that's what we did also at the Organization of American States. We tried to push for more capacity building, for more understanding of this topic, in order to impulse states from our region to try to issue national positions.
Fair enough. That is a complex terrain indeed. Let me follow up a little bit and ask you to help unpack the U.S. approach to this. And I say this with some degree of parochial interest because in my last role in government, the U.S. State Department people who did cyberspace diplomacy reported to me, and so I sort of feel like I need to know what's going on in this score right now. Help us understand the American position here. As I understand it, they don't think that due diligence has, at least in cyberspace, has become customary international law because there's not enough, what's the canonical formulation? There's not enough state practice supported by opinio juris of this, right? So states have not been acting as if this were a legal rule and for reasons that they think it is a legal rule as opposed to just being a good policy decision or whatever. So they don't think it's crossed that threshold yet, but they do think that there are some state responsibilities. So help us understand those nuances, if you could.
Absolutely. So as you mentioned, the United States has stated in a 2021 statement that it has not identified the state practice and opinio juris that would support a claim that due diligence currently constitutes a general obligation under international law. These are the two elements that are necessary to form a rule of customary international law, a binding obligation, right? So that is what the US says. There is not sufficient evidence. Some other countries have said this. Then it says, we do believe, however, that if a state is notified of harmful activity emanating from its territory, it must take reasonable steps to address such activity. So it does recognize that there is a certain level of duties that are expected. However, there is a difference between saying that something is an international obligation and not, because an international obligation would entail or even facilitate the possibility of its breach being an internationally wrongful act. If it's an internationally wrongful act, this entails the possibility that the injured state, that is the state affected by a cyber activity that comes from the territory of the country that did not exercise due diligence correctly, the injured state could even go towards or could even resort to countermeasures, right? So countermeasures are normally or acts that would be prohibited under international law, but that if they are taken just to impulse the violating state, the breaching state to return to lawfulness, then their wrongfulness is precluded. I hope I am explaining myself. So basically,
these are things presumably below the level of the use of armed force, because if you were talking about things above it, that wouldn't be countermeasures, that would be belligerent reprisal, right?
Right.
Okay.
But countermeasures could also violate even sovereignty, right? Because as long as they don't go above certain threshold, as you mentioned, but certainly this is a legal consequence of saying that it is an obligation, right? And maybe that is one of the aspects why states like the United States are being a little bit more conservative.
Yeah, it
or
also seems to me,
cautious.
it also seems to me there's perhaps there's a triggering notice, right? I mean, if you accepted due diligence as a basic principle, that would just be a responsibility that states have. And I guess you might have questions about whether they had actual knowledge of this thing happening or whether they had constructive knowledge. The Talon Manual, I think, does refer to constructive knowledge in the sense that a reasonable state in your position would have known of this attack, and I really don't care that you didn't actually know about it because it's unreasonable for you not to have known about it. So that would be sort of a baseline obligation, but the U.S. position is more triggered by whatever its feeling of those responsibilities are, seems to be triggered by notice then. In other words, whatever your baseline responsibilities are, if I tell you of this attack, you then have to do something. Is that a fair characterization?
Yes, and notice is there appears to be a consensus among states that there is not you can't expect states to know everything that's happening in their cyber world, in their cyberspace. This would actually be a terrible precedent because it would actually enable cyber surveillance, mass surveillance, right? And this is not what we want. So the notice part is I think absolutely reasonable in the sense that there are states that the obligation of due diligence or the principle of due diligence is limited to your capabilities, to the state's capabilities, and also to the fact that the state knows about it. And this has been so ever since the Corfu Channel, right? The Corfu Channel says knowingly, a state should not knowingly allow its territory to be used. So the element of knowing is essential. And they are not, I just want to convey that they are not two opposing things. Like you can recognize that it is an obligation, and you can also recognize that it emerges upon notice, right? You don't have to not recognize it being an obligation for it to.
Sure enough. As you pointed out, there seems to be agreement, whatever the agreement or disagreement on the due diligence baseline, if you will, there is agreement at least that, upon notice, there is something that one should be doing. But Andy, let me ask you a little bit about that. Notice is a great idea, but I imagine it's rather complicated in principle. What counts as sufficient notice? What form should notice take? How much information do I need to provide you? I mean, is there any understanding of what the answers are on those questions, or does the commonsensical nature of notice sort of start to get really, really complicated when you stare at it?
Sure. I think these questions perhaps are too advanced for the international discussions as of now. I think Mariana briefly mentioned states are really not too inclined to follow the should have known or constructive knowledge logic. I think most of them are against it. That also goes to for the additional layer of understanding that has been agreed by the GG 2021. So which is essentially an explanation of the norm C, which I mentioned. I refer to it as a due diligence norm, if nothing else, because of the language. It is extremely similar to the Corfu Channel case. So I think that's first. Second, when it comes to the notification, I think or what kind of notification, or what is the format of notification, what is the timeline of notification. I think these are questions that are perhaps premature, at least when it comes to state opinion leaders. They haven't really pronounced themselves on these specifics, I'm afraid. There are perhaps other reasons that hold back the adoption of due diligence on a greater scale by the states. I'm assuming. So first, I think it could be the fear of the burden that due diligence would put on the member state. That's one possibility. Even if the standard of compliance is flexible, so states must do everything in their power to comply or to prevent or terminate whatever it is, a malicious cyber operation coming from their territory. But I think the lack of, or the fear of the lack of capacity might be an issue. We also shouldn't really be focused only on a number of developed states that perhaps have issued their views on due diligence, but should look wider and what are the capacities all across the board, right? When it comes to the possible prevention or termination of a cyber operation coming from a specific from a specific territory. So that's one, I think, that is one thing that perhaps is holding back the due diligence to flourish or be adopted more on a more massive scale. That's first. Second, I would suspect that these are just my opinions, not really any official views, but I think perhaps there may be also a lack of willingness. I think there's nothing wrong if your adversary is being hurt from your territory and you just close your eyes and let it happen, right? So that's the second thing I'm assuming. The third goes back to the political process of negotiations or deliberations, multilateral deliberations within the UN on these topics. I think the priority right now has been given to the UN Charter and the obligations that stem from the UN Charter. That's something that is worth considering. And another one is probably the overarching issue is the issue of a new treaty versus the existing customary international law plus norms. So I think there's a great division between states, and again, that has been observed now in the latest discussions in New York a week ago. But states are very much on. A couple of states are still very much on the opposite sides when it comes to the debate whether the international community needs new treaty or new legal regime that's going to be very specific to cyber, or can we live and restrict or ensure peace and security through or by way of the customary international law plus the voluntary norms, which have their own set of issues, but nonetheless, that seemed to have been the prevalent opinion of, if nothing else, of the scholarship in the past. So I think it'll be a while before states agree on one or the other, if they even agree.
You're making a compelling case for why we need cyber diplomats, right? In case there was any question in that respect. I want to make sure we turn to countermeasures in a moment, but let me go back to the issue of what it is that one actually would need to do. I mean, even taking the U.S. position, let's assume that there is notice. What is one then expected or required to actually do to respond to a cyber attack? Now, you guys both mentioned the issue of capacity, and I guess one of the questions that occurs to me is, to what degree does it matter whether the country that gets notice is a sophisticated cyber power of the first rank, or perhaps a sort of an impoverished and technologically more technologically backward country, right? And it would sort of seem reasonable to hold people to different standards, but then of course the follow-on question would be, well, if there's a sliding scale that's very contextual in terms of what you're actually required to do, how is it that actors would know in advance what their legal obligations really are in the first place? And isn't that a bit of a challenge for any rule of law concept? Mariana, maybe if we turn to you to help us understand sort of what follows from, or what should follow from the receipt of notice in practical terms.
Well, first of all, just to emphasize that, and thank you for speaking also regarding the other states, right? The less developed states, and Andy also mentioned this. So there is also a concern from these states, and maybe that is also a reason why they haven't spoken so much in what is expected from them. We do have to recognize that state cyber capabilities and are extremely different between some types of states and some others. So just to emphasize that due diligence is dependent upon the capabilities of each state. So you won't be expecting a small state that has very, very underdeveloped cyber capabilities to absolutely be able to terminate a cyber threat that is coming from its territory effectively, right? But you do expect it to do certain capacity building, certain incident response plans, to have normative framework in place, to have domestic policies on the issue, to have established national contact points, and structures and cooperation, of course. What I've identified in the Americas, for example, this divergence is present in the Americas, within the Americas, right? So there's been a number of exercises. There's an excellent program on cybersecurity in the Inter-American Counterterrorism Committee that helps states also develop these programs on cybersecurity. And I think all this emphasis on capacity building is something that is expected from all of us, from all states, regardless of the discussion of due diligence, right? But it's very related, but it's something that we need to do as states to face the current challenges on security, national security, and global security.
Yeah, when I was at the State Department, I had this dream that we would build up a cyber capacity building, sort of partner capacity building bureaucracy analogous to what we have in the non-proliferation arena, and they're starting along these lines, which is very hopeful. But I get the impression we're not as far along that curve. Let me turn quickly. I know we want to get to some questions from our fantastic audience, but let me turn quickly to this issue of countermeasures. And Andy, this one's for you in a sense, at least to start with. I'd like to shift to this issue of like what happens if someone falls down on the job in terms of their due diligence, or perhaps take the U.S. formulation, their state responsibilities. In your PhD dissertation, Andy, and I hope you're not alarmed, I'm not stalking you, I was actually just interested in the topic. You said that countermeasures, and I'll quote you here, countermeasures are the only viable and potentially effective compliance-inducing mechanism in the anarchical setting of international relations. I'm not quarreling with that, but it strikes me that if you're correct, that due diligence offers, in a sense, the best chance to disincentivize bad activity without necessarily having to solve all those problems of, point of actual original origin of an attack. The effectiveness of that kind of disincentivizing bad acts is going to depend upon those countermeasures being fairly effective and fairly painful, right? So if due diligence were the rule, what would you imagine could be done to those who fell short of the standard, and who would do the doing? Under what authorities? And there's actually a question about authorities in the queue as well. Under what authorities would one do this?
Oh, well, a lot of questions. Quoting my PhD thesis was unexpected. Thank you for that. It is a dream of every aspiring academic.
I don't think anyone's ever read mine, so it's fantastic that to help contribute. So.
That was also prior to my engagement with the UN. So I think my opinion probably did shift to a degree, and I think I wouldn't be so unequivocal anymore that countermeasures are the only way to impose compliance with internationalized cyberspace. I certainly don't think this is the only mechanism, but it seems that until states agree on the rules of behavior, whatever that are, it might be a customary international law plus norms or a new treaty. I think self-help measures are probably the way to go. That is particularly in light of the fact that PhD thesis is also not the newest product of mine. But back then, I think states, the only thing states did was publicly complain and point fingers, but haven't really done anything. I thought, or I still believe, that the cost-benefit analysis is broken here, and it's very much in favor of the states that either conduct cyber operations against its adversaries, or allow them to happen from the territory, whatever that means. Now, when it comes to when countermeasures can take place, or when can states take countermeasures, or when can one state induce due diligence violation of due diligence, I think in cyber domain it's slightly different than it is in a traditional, what I constantly call a traditional doctrine, so pre-cyber legal doctrine. I've noticed quite a lot of states actually saying that a violation or state responsibility arises in violation of the due diligence only when the cyber acts coming from a specific territory, or not only they're internationally wrongful, but also have sufficient serious adverse consequences. So it seems like there's a bit of there's this 1, 2, 3, 4, 5, 6 states, I believe, that have argued in favor of that. So again, it doesn't seem much, but in light of the whole number of states, that's quite a lot. It seems like there's a threshold to due diligence that we haven't observed before, at least not until now. So I think that is quite important, and that is something that states also need to keep on discussing. I hope that answers your question, at least to a degree.
Well, that's helpful. And since we were talking about countermeasures before, let me turn back to you, Mariana. there's a question in our queue about how states envision enforcing, holding members of the hacker community to account in this respect. And I wanted to draw you out a little bit on the issue of countermeasures, which you referred to before. Now, I'm only a sometime international lawyer, so I'll defer to the experts, but I have this recollection that countermeasures are only actually technically available against states, right? This is a state sovereignty versus state sovereignty kind of thing. So what, is there a gap in the law here with regard to, let's assume that the point of origin is actually a private individual of some sort, criminal gang, who knows what it might be, and that the actual originator isn't a state itself. You may have some ability to act against the state that allows them to operate under the concepts we've been discussing, but would your countermeasures actually be lawful against the private individuals who did the harm? And how do you square that state-on-state doctrine of countermeasures with the fact that we may well be talking about all sorts of disparate private or individual actors here?
So I think a couple of issues are involved in this. So first, when those hackers are acting under the direction or the control of the state, maybe that's a more clear-cut way, the first scenario, where there would be an attribution to the state, right? Because states can operate or can conduct or direct other private entities to operate. And in this case, there's also an added difficulty. To the state, all the cyber operations that have occurred among states, none of them has been recognized by the acting state, right? So it's just the injured state that is assuming through political statements with maybe not so much evidence, we don't know, because they don't disclose, they disclose different degrees of evidence in their political statements, where they say, I attribute this act to this other country, right? So there's no acknowledgement by an acting state that state has realized or carried out a cyber operation against another state. So, and then there's the technical difficulties of attribution, right? The political difficulties, but also the technical difficulties. How do you really prove that the hacker or the person that was behind that computer has any link to the state? So this is very difficult. And probably this is the reason why to this date, it's been limited to political statements. There have been no cases before international tribunals because the law maybe is still unclear because of these processes multilaterally that are still in process. What happens if there is no proven connection with the state? There is a number of states and of academia that also say that the countermeasures can actually target a private company, because if what you're saying is that the violation was by the state violated its obligation of due diligence, of not carrying out the termination or mitigation activities of private entities within its territory. So countermeasures must not be, they don't have to be the same act, and they don't have to be exactly against the same breach, right? So an injured state could possibly attack a private company within the acting state that is not exercising due diligence, which is the company that is going against it. So I would love to hear Andreas's view on this. Yeah.
So countermeasures would give the wounded state, if you will, the ability to violate the sovereignty of the harboring state enough to move against the threat, but the authority to move against the threat directly, if it were a private threat, isn't necessarily on the basis of countermeasure. It's just a different question. You've got permission to violate sovereignty in effect from this rule. And I don't know what authority you ground the action directly on, but perhaps that's just a different thing entirely. Andy, what are we missing here, if anything?
No, I think that was a fairly good summary. I think one thing that may need emphasizing here is, I think that is the beauty of the non-state actors, the question of non-state actors and the proliferation of cyber operations by the non-state actors against states in violation of their, not really violation, but deprivation of their legal rights. I think this is the beauty of due diligence and state responsibility based on due diligence, where states that have been injured by certain cyber acts could act directly, not against the non-state actors, but the harboring states. But that doesn't mean that countermeasures, when I'm saying act, I actually meant the invocation of state responsibility. But when it comes to countermeasures, I think states are fairly, I think states are allowed to take countermeasures against non-state actors as long as these non-state actors are, that's my argument, as long as these non-state actors would be situated in a territory of that state that they find to be internationally responsible. And as long as the final goal of these countermeasures is to induce compliance with international law, so to impose some sort of diligent measures to, in that particular point when a cyber operation is undergoing, to stop a cyber operation. Now, what international law, at least again the traditional doctrine, I don't know whether the law is going to develop in a different direction now in cyber context, but states are not allowed to take countermeasures against states that are not party to the conflict in order to induce compliance of another state. I think that with multinational corporations that have infrastructure all around the world may actually be a bit of a restriction on countermeasures when it comes to the violation of due diligence. So that's something that is I think quite important.
Interesting. Okay. Well, there's a question in the queue here, or at least an appreciation in the queue for Mariana's list of non-cyber related precedents for due diligence, human rights instruments, environmental law, that sort of thing. Now, too much to go into that in detail here. It's a little off topic for us, but the precedential value is fascinating. And so maybe this is for you, Juliana, perhaps as a homework item we could maybe collect from Andy and Mariana, some sort of greatest hits of other things that are, analogously relevant here, and perhaps make them available to folks who access the website afterwards. I think that'd be a valuable service.
We put on the website, and as well when we shared the recording with an email, cool. We can also share through that.
That sounds great. But it does put me in mind of another question sort of spinning off of that, and that is for either one of you, Andy or Mariana, wants to take this. Given that there are, I think, Andy, you referenced the idea that there's a sort of a general principle that it seems to be understood in international law of, due diligence-ish sorts of thinking. I guess the question is, to what degree is cyber, and if so, why, different from those things where it is perhaps has a more long-standing acceptance? Or is it not different? But how do you distinguish the cyber domain, if you will, from where these other precedents are, have evolved, and what distinctions that may force us to make, and to what degree those concepts are transferable to this one? And that's for whoever wants to jump in.
You can go, Andy.
Sure. Okay.
Yeah.
One thing that comes to mind is related to the constructive knowledge, at least I think. So constructive knowledge, even though it hasn't been really recognized by a lot of states, it could be that due diligence is going to develop in the cyber domain in this direction. But I think what is quote unquote worrisome, at least hindering on the development of the law, is that states have been very clear that due diligence does not require states to monitor their infrastructure located on their territory for any potential cyber operations coming from the territory, and depriving other states of their legal rights. I think by removing that, the monitoring aspect, even though probably majority of states do it already, but by removing that requirement, I think the constructive knowledge here is out of a window, and I don't think we can count on it. But nonetheless, I think the constructive knowledge is the powerful element of due diligence. It's very easy to say for states that, well, we didn't know, we had no, by virtue of that, there were no expectations towards our behavior to try to prevent a malicious cyber operation coming from our territory. I think that is the specificity of cyber, because I'm aware that it might be much harder to observe cyber operations coming from an infrastructure that is, just by nature of cyberspace, it's invisible, and it's probably much harder than observing the laying of the mines in a specific channel. So I'm referring to the food channel case. But even then, even there, the ICJ couldn't really establish whether Albania knew of that or not. But they studied they did quite a lot of studies, but essentially at the end reached a conclusion that not only that Albania in the past was observing this particular channel, and that the weather conditions and distance and so on allowed certain operators of Albania to see the mine laying process. So it was also based, that state responsibility over there was based on the fact that Albania should have known of this. So I think perhaps the international community should look into should have known, and should look into constructive knowledge, and that could actually help be helpful in cyberspace.
Well, constructive knowledge strikes me as being basically sort of a reasonableness standard, right? What would a reasonable state have done in your circumstances? And if you don't live up to that standard, then you are deemed to have, whatever, to have known of something that you would have known of had you been more responsible. But reasonableness is something that requires some degree of a, sort of accumulated practice of a community, right? I mean, you wouldn't ask, we may have what would a reasonable driver have done under the conditions of the traffic intersection down the street here? You wouldn't ask what a reasonable driver would do to someone who was just beginning to transition out of the era of, horse and carriage to automotive transport, right? I mean, it was only you can only have that conversation intelligibly if there has at least been some acquaintance with this new, whatever this new thing is about which you're asking. Is the cyber domain maybe just still too novel for ideas of reasonableness here to have accumulated in a way that would be compelling to countries in terms of signing off on a new approach? Or maybe I'm overreading it, but perhaps the elapse of time will help to some degree. What would you add, by the way, to Andy's comments, Mariana?
Well, I would definitely add the difference between the cyberspace being physical and non-physical components to other domains, right? And also the difficulty of jurisdiction. For example, in international human rights law, we have very delimited obligations within the state's territory, right? Or persons under its jurisdiction. International humanitarian law recognizes that there is not a territorial limitation to its obligations. For example, for example, this duty to ensure respect for IHL in other countries as well. Even the genocide case, there's been a case that determines that one state can be responsible. Serbia can be responsible for the Bosnia-Herzegovina for not preventing or not doing enough to prevent because of its geographical proximity, its possibility to influence. So we do have this issue of jurisdiction normally in international law. And then suddenly we face cyberspace where jurisdiction is not so easy to delimitate because many of cyber operations go through many states, actually. So there's also a whole debate on what the state of transit is expected to do, right? So many cyber operations go beyond states and go through many states and through different actors. And I think this is one of the main elements of the difficulties in this arena. How do you enforce responsibility to all the states involved? Is there, as Andy was mentioning, the constructive knowledge, which is like you should know. It's not only the activities that you knew, but that you should have known, right? So that's very much under debate because of the burden that it would impose upon the state that should have known, because you can say that every state should have known, right? So this is a debate. This is still in debate.
Fair enough. I know we are not too far from the bottom of the half hour, as it were, at the end of our hour here. I would like to give each of you the chance to offer some thoughts about the future. Where should we be going with this? What are next steps? Or what should countries, in these diplomatic engagements, what should people be trying to focus on to move the ball forward here in a constructive way that has some, reasonable chance of forward movement and actual success? I don't know who would like to go first, but give us all your thoughts for, what's the next step in our collective agenda here, if you had the ability to steer us in that way.
I can start. I would definitely urge states to issue national positions and hopefully to state what they think about due diligence. We mentioned customary international law formation a few minutes ago, and it's only through knowing what states think about existing international law and how it applies to cyberspace that we will be able to know if a new specific law is needed. But until states don't speak up, there is an impasse. There cannot be any moving forward. So this is why national positions are so important. And I would definitely think that hopefully by the end of 2025, there are enough national positions to move this forward. And so it's not another 2 decades of discussions and we start seeing results in this.
Fair enough. How about you, Andy? Thoughts to guide all of us?
I think it's really hard for me to talk about should. This is my personal opinion, not an official position. But I think obviously what we always say, states should continue discussing the rules and principles and law that apply to cyberspace. And when I say states, I mean the multilateral discussions that have shown a tremendous value in producing a number of reports that have been quite useful, I think, in studying how the law applies and how the states see the development of the law in the ICT domain. That's first. Second, when it comes to the customer international law, yes, I'm inclined to say more rules is better, at least in this context. But we have to be mindful that a number of states reject the development of customer international law in this domain, saying that we need negotiations and not something that not rules that will develop through time, because that, in a sense, at least that's what their argument is going to be way too late and too slow. But nonetheless, if we do go down the customer international law route, I think what's missing right now is the indication of state practice. We see, I mean, compared to the state practice, we see quite a lot of national statements or opinion juries, but we don't really see the state practice. Now, if we're talking specifically about due diligence, I think states should show how they are following the due diligence principle, be it a norm or rule, whatever they consider it in this domain. But I think they should show how they are preventing or terminating cyber operations stemming from their territories. Sorry, and I think that would be a useful addition in building the customer international law if we go down this route.
Well, certainly over the last hour, we've walked through a whole range of issues about which there is lots of talking and engagement and discussion still to be done, right? And we have issues of whether or not there is, in fact, customary legal basis for due diligence. Even if there isn't, what state responsibilities attach upon the delivery of notice, what sorts of notice actually count or should count in this respect. If you do get notice, what then are you obliged to do? To what degree does state capacity affect what it is that you might be obliged to do, and how do people know what their legal obligations are in this context? And oh, by the way, if you fail to perform them, what can others do to you? These are all enormously important questions that we've raised. I guess it's been too much for us to answer all of them, but certainly pointing to them is important. And I guess, as you all were just pointing out, whether you are articulating a state position with respect to opinio juris in a customary international legal question, either to support formation of a new rule or to object to it, I suppose, right? Or whether you are actually negotiating a new treaty or instrument in a more explicit and formal sense. Under any of these scenarios, there is a lot to be said for openness, honesty, clarity, engagement, and people trying to talk these things through thoughtfully. And that is where you all have contributed, I hope, enormously to our listeners today. You certainly have to me. And I am sure I speak on behalf of the Washington Foreign Law Society and the Stimson Center in saying thank you so much for being a part of this discussion. I'm waiting to hear where this series of events goes next. It's been really, really helpful and interesting in drawing these issues out. And I thank you so much for your contributions and for being willing to share your part of your day with us. And thank you also to our listeners for being here, Juliana, and of course to Washington Foreign Law Society and Stimson for making this all possible, and their supporters as well. I've had a blast. Thank you guys for being part of this, and I'm sure all of us will join you in at least a virtual clap of great appreciation to you all for being part of the show.
Yes, thank you. Thank you to all for enriching the discussion, and thank you, Christopher, for moderating it. Follow us for the next panels, but also to re-listen this recording soon. Thank you. Bye-bye.
Thanks so much, you all.
Thank you.